Very good evening, ladies and gentlemen. We've heard from three eminent speakers, all of whom had dealt with their subject matter at great detail and length, especially Joao with his secret assignment on the CISG. We'll probably want to hear more from you on the CISG after this. But perhaps I could start off the moderation session with a question or request for comments from Faris and Professor Ismail in terms of operation of Section 56 of the Central Bank of Malaysia Act and Rule 11 of the I-Arbitration Rule. Do you see these as being so diverse as to be an impediment to the development of I-Arbitration in Malaysia?
No, I don't think. I don't think so. I think it is actually helping to speed up the arbitration. It serves a purpose. It prevents unnecessary dispute and argument among counsel or experts and so on. By providing this machinery, it says, okay, this is going to be the Sharia. The Sharia will be determined by the SAC, and that should be binding. It's a very simple, straightforward sort of a solution to a rather complex problem.
Faris?
I definitely agree with the benefits. The predictability is certainly one of the things that will assist in the speedy resolution. Having said that, there are, when you look at cross-border enforcement, there are certain issues that start to arise when you characterize who has the power to actually determine the different aspects of the dispute. The strange thing is, in our conversations with Bank Negara, I think much of it just comes down to the wording of Section 56. I don't think they actually want it to be binding in the way that we understand it to be binding. I think that in the coming 12 months or so, there will be some resolution to this issue, and I hope that there will be. Things unfortunately tend to move a little bit slower here, but as I said earlier, our point of view is that as far as the arbitration is concerned, the procedural rules and the procedural law, there's nothing that is taking away the determinative power from the tribunal. It's merely an issue of external mandatory law, if you will, being the Central Banking Act, and that's something that may need to be resolved externally.
Is there any comment from members of the floor or questions?
Hello. My question is, how popular is I-Arbitration at this moment, and to date, how many cases have been heard by KRCA with regard to the I-Arbitration?
We've not registered any disputes, which is not to say that it's not been popular. We know that the rules are being used in contracts. There just haven't been any disputes that have been arisen that have been referred to us. I'm not sure how likely parties are to reach dispute. When you compare it to more conventional commercial relationships. As we said earlier, one of the important fundamentals of Sharia compliant transactions is the idea of sharing of risk, and what comes with that is certain cooperation when things do break down. So I think the proclivity to actually have a dispute arise is much less. Having said that, we know from information that the rules are being used, and we are waiting for the first case to be registered, which you'll all know definitely when it is.
In fact, I have sat as arbitrator in 2 Islamic arbitration matters in KLRCA. One is a three-member panel involving an Islamic bank and a private company. There was a Sharia issue that arose in that matter, We referred it to the Sharia Advisory Council, and a ruling was given. We applied the ruling in making the award. The award was challenged in the High Court. It was unsuccessful. There was an appeal to the Court of Appeal. That was also unsuccessful, and therefore our award stood. The second one was single arbitrator. I was the sole arbitrator in that. And one of the parties wanted to adduce expert evidence in that arbitration. So I said, no, you cannot adduce expert evidence. And I would decide the matter if I'm able to. Otherwise, I'll refer it to the Sharia Advisory Council. And I made an interim award based on that. That was challenged, taken up to the High Court, and they were not successful. Subsequently, the parties settled the dispute.
Professor Ismail, could you just clarify the two matters that you were doing? Were they domestic or international arbitration?
Both domestic. Both domestic.
So there's none for international today?
Not to my knowledge.
Yeah.
I should clarify, those are both ad hoc cases as well, so they're not referred to the KLRCA under the I-Arbitration rules. But we did have previously a set of sort of Islamic arbitration rules that were purely for domestic and quite limited in terms of the type of transactions that could be referred under those. They were, I think it was a 2007 set of rules. We had, I think, around 10 cases that were referred to us under those.
I become notorious for asking questions. So I don't ask you, Faris. I Googled what I wanted to ask you, and Mr. Google got me an answer. What is the abbreviation of AAOIFI? So I won't ask you that. But I have a question for you, Professor Sharif. You said that for a Malaysian court, the question of Islamic law is a question of the law of the land, and as such it is not foreign, so there is no possibility to seek expert evidence on that. And I think that's absolutely clear. I think we have the same thing in Germany. Even if there is a complex matter, a judge would not know about it. If it's part of the law of Germany, he cannot seek expert evidence. What I was asking myself, where actually is Islamic law codified in commercial and civil matters in Malaysia? I think the only act is the IFSA, International Financial Services Act, and I do not see from outside any other Islamic law governing civil and commercial rights. Am I right in that, or is it completely wrong? Where is, for Islamic commercial and civil matters, Islamic law codified in Malaysia?
It is not codified here, although there are certain codes on Islamic law. For example, Turkey, we have got the Mujalla and other codes, but they are not used here as law here, but although they are used for reference purposes. So at the moment when you talk about codification, there is no codification of Sharia law, but it is being built up by means of the Sharia rulings and court cases. So it's very much like common law, which was developed through the cases. Here, in addition to the cases, the judgments given by the courts, we have the Sharia rulings. As I said, they are published, and the parties can refer to those rulings. Hopefully, over the course of time, maybe there could be a commercial code developed in Malaysia, at least, for use by the trading community as a whole. But at the moment, there is no code as such.
Just to stir the pot a little bit, perhaps. Yeah, I mean, I guess that's one of the issues with the way that Sharia law is sort of codified. In essence, it's almost incorporated by reference to the guidelines. So you have a situation where you have what is effectively an administrative body, the SAC, writing law. And whether that is a tenable situation or not, is one of the things that gives rise to some concern. I don't know if Professor Dato has the same opinion or not.
Well, the question is, if not SAC, who else? Who else will determine the law? Here we have got a legal setup by statute, a body that will determine the law for you. And that determination is binding. I mean, I see the benefits of it because, I mean, we can sit down and argue about which one is the appropriate rule that should apply. There are the 4 schools of jurisprudence, and within that there are many differences of opinion. And of course, you've got any number of Sharia scholars all over the world who have got their own opinion, very much like lawyers. I mean, lawyers do differ, and that's how they thrive. So how do we reach a settlement? Because we need certainty in the law, especially cross-border transactions and even domestic transactions. If we leave it to all and sundry to decide, we are not going to have a harmonious sort of a situation. So whether one likes it or not, this is one way of, if you like, imposing certainty and uniformity in the law. And I think that is a welcome thing.
This question is for Faris. You mentioned just now that you had some discussions with Bank Negara on the whole Section 56, 57, and you said that the indication from Bank Negara was they didn't think that the word binding would be interpreted as such. Can you then kind of explain to us in what manner did they, what did they mean by binding?
I think Professor Dato has actually just done it for me. The intention is to, the intention is just to create a harmonized body of law that that people can look to and with some certainty and know what the law is that's applicable. The intention is not to give some other body the ability to tell an arbitrator or a judge what to do. It's just to create a body of law. So, I mean, for example, the issue doesn't go away, but the issue changes. The complexion of the issue changes a little bit. So my issue becomes not, okay, well, now you're telling this person what to do. My issue becomes, well, should a body such as the SAC be the one writing law? Isn't that supposed to be done by, by specific other bodies? That becomes the question. So I think that the intention is a noble one. It's the same as UNTRAL wanting to with the CISG wanting to create a harmonized, predictable text that can be used as a body of commercial law. It's really the same concept. It's simply the Malaysian government wanting to create a clear, harmonized body of law that can apply to Islamic banking and finance. But I think the way that it's being carried out by sort of delegating that role to the SAC is is what is giving rise to all these issues. I don't know if that makes.
If I may comment on that.
Yes, please. Dato.
In the beginning, there was no such provision anywhere. I think it is about 2000 or something. The Central Bank of Malaysia Act 1958 was amended by the incorporation of Section 16B. Under that, the Sharia Advisory Council was set up, and its rulings were said to be binding on arbitrators, but the courts, it said, may take into account such ruling. They were not bound by it. But when it was, the act was reenacted into Central Bank of Malaysia Act 2009, the rulings were made binding on the courts. But if what I hear from Faris, if Bank Negara is going to take a step back, I think it's a backward step. Thank you.
Well, it's not necessarily a step back. It's more of a sideways. It's a step to clarify. So you know, think of it as a tango. It's, yeah, I wouldn't say it would be a step back. And look, I mean, these are preliminary discussions, and I can't pretend to know what the end result would be. But there is certainly some confusion and some issue that is given. I don't think we can dispute that. And it is something that they are cognizant of, and something that I think will be dealt with, and I hope that will be dealt with fairly soon.
Professor Dato comment that Rule 11 is the only distinction between the ordinary KLRCA arbitration rules and the I-Arbitration rules. And if that's the case, would Islamic parties find any other rules, perhaps, of assistance in I-Arbitration?
I personally don't think so. We don't have to reinvent the wheel. There is already a system in place, working well, and before the introduction of the I rules, the arbitration rules applied and disputes were resolved. Now it is made a little bit more acceptable to Sharia disputes by having these arbitration rules. So I don't see any objection to those rules remaining. I think it's a very good sort of a forward step that KLRCA has done in this respect.
We have encountered some, some objection from certain parties, but again, the I-Arbitration rules will not be suitable for all, Islamic transactions. A transaction between, two parties in the Middle East, both who are happy to accept an entirely Islamic procedure. There are organizations in that region that will provide that. That's not what the I-Arbitration rules provide, and that's not what we seek to provide. So in that respect, there are sort of those two different tracks.
Good afternoon. My name is Marjolein. I'm a Dutch attorney currently living in Kuala Lumpur. And I want to thank you for your speeches today. I was wondering, obviously the SAC has quite a lot of authority in this. Who appoints the SAC, and what qualifications do the SAC members have or have to have in order to be a part of the SAC? Thank you.
The SAC is established under the Act of Parliament, and the members are appointed by the King, by the ruler, the King, on the advice of the Minister of Finance. Of course, following the recommendation either by Bank Negara Malaysia or Securities Commission. And the council comprises about, I think, 12 members, the majority of whom are Sharia scholars, and we have bankers, ordinary lawyers like me. I'm one, just one lawyer there, and bankers and so on. So it's a mixed group, so that it is not purely Sharia as such, but the broad representation gives the ruling a greater acceptance because all angles are looked at. It's not from a purely Sharia point of view. Whether it is practical, it's another issue. Whether it is in conformity with the existing laws or how we can make it. So it's a sort of a mixed group, but mainly comprising of Sharia scholars. And the rulings have so far been well accepted by well, they have no choice really. But I don't see any sort of major, of course, there has been challenges to the constitutionality of the provisions. There have been questions about usurping the power or jurisdiction of the courts. It's for the judges to decide, and then why are you taking away that jurisdiction and so that power and so on. Well, that has been dealt with not by the highest court yet, but the second tier, the Court of Appeal, and they have said this is actually, if you look at it closely, it is merely like expert evidence. Here's somebody, you have got a problem, you've got an issue, you can't decide the issue yourself, but here is a body set up to give you advice on that issue. So you just accept it and go ahead to decide your case, just like a medical issue or an engineering point. I mean, is this doctor negligent in giving this treatment to the patient? How would a judge decide that point? Of course, he has to get expert evidence. Or any other engineering point or any other matter that is outside the legal sphere, which is within the power of the judge to decide. So likewise, this is an issue, although it is an issue of law, but it is Sharia, and the judges at the moment are not competent in Sharia. I don't know whether they'll agree with that or not, but that's a fact. So here's a body that's giving you free advice. I mean, you call an expert, you have to pay him a big amount of fee. And the other side will call another expert, and they'll incur a lot of expense. Now, all that is cut out, and you have a speedy resolution. So that's how the Sharia Advisory Council, and I can tell you, the Sharia Advisory Council, when an issue is referred to it, delves into it from all angles. It looks at various opinions, various Sharia rulings, and so on, and it is not confined to any particular mazhab or school of jurisprudence. Not Shafi'i, not Hanafi, not anything. They look at all and say which is most appropriate for this situation at this time in this country. That is the sort of governing principles that are used to come to a decision on any issue that is referred to the SAC. Yes. Oh, yes. All 12 members. Yes.
If I may add, just my opinion, I think there's good jurisprudence behind the what I call the SEC having that exclusive so-called exclusive power to look into the Sharia matters, simply because I look at it from the perspective of potential constitutional conflict pertaining to the jurisdiction of the civil court and the Sharia court. Because as we know that we have dual court system here, the civil and the Sharia, and both system has been given the legal power under the federal constitution. So if the civil court system judges were to make ruling on Sharia matters, which happen to be commercial in nature, but route into Sharia legal ruling, then it would have transgresses into the Article 121A. And that would definitely leave rooms of future conflicts. That is my humble opinion.
Well, we are now entering into rather difficult territory. Now, under Schedule 9 of the Federal Constitution, we have got List 1 and List 2. List 1 contains the matters over which the Federal Parliament can make laws. List 2, as you know, state legislatures can make law. And the extent of jurisdiction for the state legislatures and thereby the Sharia courts is confined to Islamic personal law only. They have no jurisdiction to enact any law regarding other matters, banking, companies, commercial, anything. All that is with the Federal Parliament. So in terms of the lawmaking power, I don't think there is any conflict. Although the impression is that there is conflict between these two. But the Constitution is very clear. The lines of power or jurisdiction are clearly demarcated. Sharia courts only, Islamic law insofar as it relates to personal matters. Marriage, divorce, custody of children, administration of property, wakaf, and things like that, and not commercial or other matters. That's within the power jurisdiction of the Federal Parliament.
I have a question for Joao, if that's all right. As I mean, you know, uns Joao one of the main tasks, of course, is harmonizing different areas of law across the world. And you mentioned that you bring together jurists from common law, civil law, Islamic law, for the purpose of doing so. Do you have any thoughts or advice as to how the same can be achieved, looking at Sharia law and the chasm, if you will, between the different geographical and other influences?
I'm assuming that all our texts already have done that, in the sense that if you have representation from all these jurisdictions, the result that comes out of it, in principle, is a result of all those discussions. Of course, this is a theoretical approach. We know that in practice, for the first few years of UNCITRAL, we can recognize that the US, Canada, Europe were much more active in those discussions. But we have seen in the last few years other jurisdictions from Asia and Islamic law jurisdictions to be quite active in the discussions. So in principle, our standards are already that. So I would say that UNCITRAL standards should, in principle, also reflect some kind of harmonization from the different schools of jurisprudence, even within Islamic law, since as you have seen from the states that are parties or that participate in the discussions, they reflect different schools of jurisprudence from Islamic law. But I'm quite aware that this is a very theoretical answer.
Can I just ask you one question on Article 78, the non-reservation? What's the philosophy behind it, not allowing the reservation?
The philosophy, well, it was, the CSG already allows for quite a number of opting out discussions. I haven't seen in detail the discussions because there are no minutes to go to the detail of the discussion to see why it was not allowed in particular 70, the reservation. The principle of not allowing reservations to the convention was that that would be a key point to further harmonization and unification. Otherwise, it would be very hard to achieve that. And even like this, we can see that hardly common law jurisdictions are embracing CISG. So even without any reservation. That was the principle, to allow for the convention to be stronger and to further unify and harmonize the sale of goods contracts.
Sorry for...
I know that's... Those are the questions that I need a diplomatic answer. Let's say that the fact that common law jurisdictions are quite integrated to a certain extent and follow the English Sale of Goods Act, of course, and because these jurisdictions are also very much active in international trade of, and sale of goods, obviously that prevents CISG to be much more popular. But please do not forget that, for instance, China has embraced CISG, and that has been a great contribution for CISG to be more and more popular. The fact that developing economies are seeing more SMEs engaging in cross-border trade is also helping CISG to become a standard for the reasons that I mentioned. It's a default law, and for that matter, most of the contracts will fall under CISG by default. So the main reason I would say would be that very strong jurisdictions, common law jurisdictions, because they are not parties to CISG, do not allow for further expansion of CISG. But it's a matter of time in any case. We hear some discussions in the UK that because they are a bit afraid of European law, even though there was a recent failure, they might consider joining CISG because it would be better than any European law on the matter. So let's see.
So is the traditional common law, civil law?
Well, it's CISG is again, there was a huge work to bridge differences, and some of some of the provisions of CISG bridge that difference, and there are some concepts that sometimes are a bit unclear because they try to bridge those differences. So CISG is a result of those discussions to bridge the difference between civil law and common law. The US is party to the CISG. Singapore is party to CISG. Australia is party to CISG. So there are several common law jurisdictions that are parties to the CISG in any case.
Just to jump to Joao's defense as well, I think, when you put it up there next to the New York Convention, which is incredibly successful, I mean, of course, the CISG is going to look like, okay, why is it not catching on? But, in fact, I would say it already is successful and already is catching on. I think the New York Convention is just an outlier, with the 155 states.
Sorry. I was just thinking, it sounds to me like everyone's assuming that people will engage experts on Sharia in disputes. And the thing is, that's a choice of the parties, or either a choice of the judge, whether the parties don't feel like appointing one. So if I could get the panel's opinion on this, what happens then when none of the parties want to seek expert evidence on what the position is on that Sharia law? Neither does the judge want to, and it's left in the good hands of a judge that isn't competent to decide. And we've actually seen that was actually what did happen before the amendment came about, where this a particular judge had actually, in a number of cases, invalidated BBA financings on his interpretation that they were non-Sharia compliant. So if I could get the panel's view on that, then.
You said as judges invalidated a number of BBA transactions?
Yes, previously, before the amendment.
I see. Because now it's very clear the Court of Appeal has made a ruling that BBA is a valid transaction as far as Malaysia is concerned. Well, coming to your first question, if there's a Sharia issue and the council don't want the issue to be referred to the Sharia Advisory Council, and the judge also doesn't think that it is necessary to refer, then everybody is blind to the issue and they get a judgment that they deserve.
Sorry, Dato, but actually what I was saying is if no expert opinions or experts, the parties engage experts, like either the plaintiff or defendant, they will engage an expert to give the expert opinion.
So they are aware of the issue, but they just choose not to collect it. Well, I mean, yeah, if you look, commercial arbitration, one of the reasons it became so popular was because, look at construction, for example, the parties are able to appoint an arbitrator who is experienced and has the knowledge to deal with the dispute without the need for expert evidence. I mean, that's one of the reasons it's been so successful. So it's not an abnormal thing, and it's something that is contemplated. The position, I mean, it comes back again to mandatory laws. If the parties are content to appoint an arbitrator who has the expertise or sufficient expertise as far as they're concerned to deal with the dispute, him or herself, well then that's as far as we're concerned, and as far as arbitration procedure is concerned, that's fine. Whether that's permitted under the laws of Malaysia is a different question. Whether the arbitrator is forced to refer any issue that comes up to the SAC, or whether the arbitrator is free to simply look at the SAC's guidelines and apply them him or herself, or whether the arbitrator is free to disregard those guidelines and deal with the dispute on their expertise. I would submit that is an issue of mandatory law under the Malaysian law, not something under the arbitration procedure. So as far as we're concerned, under arbitration, that's perfectly fine, and that's something that it's actually meant to happen.
But if in a court proceedings or even in arbitration, if I'm sitting as an arbitrator and an issue comes up, the Sharia issue, in the absence of any published ruling, previous ruling of Sharia Advisory Council, I would not take it upon myself to make a decision. I don't consider myself to be a Sharia expert. So I want to be fair to the parties. I want to deliver a judgment or award to them that would be in conformity with the law. and here is an issue about which I'm not sure, and there is no published ruling, I would, in the ordinary course, refer it to the Sharia Advisory Council. Then my conscience is clear, because that's the other element in giving an award or a judgment. You have got to be you have to be clear in your conscience that you have given an award that you know is fair, all right, and that you have not arbitrarily decided an issue thinking that you are capable of doing it. When I'm not an expert in it, I wouldn't go and decide that issue just on my own. I would take the cautious way of referring to the SAC, but others may take a different view. Faris might.
No, I just wanted to ask a follow-up. So one thing that parties often select to do, and it is very common, for example, with our fast-track arbitration rules, where parties essentially are saying we're happy to forfeit, some of the quality of the arbitration in exchange for a quicker, cheaper decision. If the parties were to say to you, we're happy for you not to go to the SAC, we're happy for you to decide this yourself to the best of your ability. That's what we're asking for you to decide on the basis of the submissions that we've given you, so that we can get a quicker award. What would be your approach then?
Well, it's your funeral. I mean, in a way, I'm sorry to use the term, but you want it that way. It's not that I want it that way. You want it, you're prepared to take that at your risk. So I decide. My conscience is clear.
Party autonomy.
Party autonomy, yes.
Has the SAC made its rulings available to the public?
Yes.
So if in future,
Published. It's into the second edition now.
If in future the same issue arises, any arbitral tribunal or court can just adopt those rulings.
Yes, that's right.
Thank you.
It's available also in book form. Hard copy is available.
On the website as well.
Yeah, website as well.
Can make it very clear, I know nothing about Islamic law, but just from what I've been listening this whole day, and it's been extremely interesting, something pops to my mind, which is ordinarily in the system of lawmaking, and deciding law, you have a clear separation of powers between the government, legislature, and then the judiciary. But by the fact that you have now the SAC seemingly making the law, and then deciding that law, doesn't it infringe the ordinary separation of powers?
It's quite late in the day, to ask. Well, yeah, from a common law point of view, there may be a transgression of the limits, the separation between judiciary, legislature, judiciary and executive. Huh? But are we strangers to that in Malaysia? Sorry to ask that question. But yeah, I think here, although there may be sort of blurring of the territories of these two, it's a necessity of the time. I think Malaysia is committed to developing Islamic law and Islamic banking and finance, I mean, and you need to develop the law in tandem with the growth of Islamic banking and finance. And I think in the absence of Sharia-trained judges in the common law tradition, of course you've got the Sharia courts who are Sharia-trained people, but they are not trained in the common law tradition. So here we have got to marry two things, common law tradition as well as Islamic thing there. So until such time as we have judges who are qualified in Sharia as well as in common law, say, that sort of judges we have, this is the interim measure, if you call it. And it's a necessary measure, although there is a blurring of these thing there. I think it is not only in Malaysia, but many other countries, there has been which legislature is totally free of executive persuasion. You know, there is even in the Commonwealth countries, it is like that. So I would say that this is a necessary step in the development of Islamic law for Islamic commercial transactions. Thank you.
Is there any further questions? We can take maybe one more if anyone has any questions. If not, then let's give our speakers a warm round of applause for today.